to ask
Yeah.
the two professors a question, since both of you have supported the judgment, and Professor Bakshi has rightly said that don't expect too much from this fine-tuning exercise. The judges have said no radical change. That's reported also in the media. So I'm giving you a fact situation, because so much of this judgment, of these judgments, are based on empirical knowledge of the judges about how certain law ministers pushed appointments, etc. Now, both of you don't practice, but both of you have sufficient exposure to courts in your activist roles. Now, here is a collegium of 3 judges, let us say. And the fact is that the profession is hereditary and dynastic. We can't wish that away. Professor Bakshi, you've lived long enough in Delhi to understand me when I say that this phenomenon of Sada Damad Twadi Bahu, I hope you get what I'm saying. Now, this is a reality in the courts. Justice Chalameshwar talks of trade-offs within the collegium. Now, who is to check this? Who is to check this? One relative makes a killing in the other judge's court. The other relative makes a killing in this judge's court. And the third judge is a good friend of both these other judges. And he is, after all, uncle to the lawyers concerned. Now, can there be in this utopian, because this is the level of utopia we can achieve, can there be a check on this? Who is to interrogate these judges?
That's a very, very, very legitimate question. I'm glad you put it to all of us, and we will consider it. I said in my observations, I said again, that Parliament has plenary powers to bring forth a national collegium, accepting that this particular act was not it. How do you safeguard why do in a country of 1.3 billion, Prime Minister says all the time, and that I remember, and I represent 1.5 billion children. I don't know. But I don't represent anyone. I find it very difficult to, I don't know what the meaning of the word represent. But some people know. And so 1.5, why do we have only 6 members in the collegium? Why do we have only 538 members of Lok Sabha and Rajya Sabha? Why is that amendment which freezes the amendment which freezes the population by incentive to control population? The number of states Uttar Pradesh and Bihar would have. Why not we have a parliament of 2,000 people? Who has laid down out of 1.5 billion people, 2,000 is what percentage? So why do I think there is possibility in Parliament to make a collegium of at least 50 members, or 30 members, or 15 members, why 6, in which I would insist it should not be called, whatever the rules and procedure may, that the Justice or Secretary shall not be convener. It cannot be when you are dealing with constitutional karcharis like President the Chief Justice of India. So convener, you have to work out some method, and you should give primacy to the collegium, there should be more judges whose views will be normally respected, but that could be overcome by veto or majority opinion, certainly. So I would prefer a collegium system which is more broad-based. I would say eminent person, the constitutional amendment should lay down the criteria. I told to Chinappa Garo, Justice Chinappa Reddy once, I said he was very angry with me. God bless him, by the way. He was very angry. He stopped talking with me. I said, that time Mother Teresa was there. I said, Mother Teresa and Baba Amte should be eminent persons. There are two outstanding Indians that have been produced by India. See, what do they know about Chinappa Garo said, what do they know about judging? I said, that's the point. They don't know a damn thing about lawyers and judging, but they know who is a good person. They're a good Indian who cares for the poor as for the poor. So eminent persons, I agree, but not to be nominated by executive of the day. My goodness, I would not trust any political party in India today to nominate the eminent. But they don't see eminence what they see. They don't like eminence. Therefore, you don't eminent person, there must be procedure for it. I'm saying Parliament in its wisdom can provide a collegium which is very different from the Act now passed, which finds a way to give some sort of primacy to the judges, increase the number of judges, but also finds a way to be really representative. You should study South African Constitution, South African Court. People have to apply for justice. Trade union person is part of the collegium. They're the commission. So there are a number of ways in which Parliament can pass a result. This was not it.
But Professor, I think I still haven't got an answer to my question. Now, you suggest that there can be a 50-member collegium. Let's take 50 as a figure with broad-based representation. But going by your theory of primacy, this 50-member collegium must still have 28 judges, because primacy means not just significant chunk of representation, but majority. And so whether it's a 5-member collegium or it's a 50-member collegium, where the interests of judges are involved, the judges will still be in a majority. That's my difficulty.
I suggest, offhand I suggest all the Chief Justices of the High Court, and 5 senior most, 6 senior most judges of the Supreme Court is good enough judicial presence. But they have no veto power. Nobody should have veto power. They should decide either by unanimity or by majority. Primacy is qualitative, not quantitative in my sense. That you must have very good reasons to reject what the judges say, good judges should not. But if you have good reasons, you must support them and override the judges. And that's where our Amte or Mother Teresa would come in equalism, or equivalence of them. I don't want to go into who are equivalent today, so there are very few. But in my time there were plenty. Maybe there are plenty this time also. Maybe Nobel laureate we have produced one after Tagore. He can be. Anybody can. I don't care. But I think the eminent persons should be increased and should cover all strata of society. I'm not sure if somebody made the point about transgender. There is a judgment on transgender also. And there's judgment on gay. They contradict each other. So you can have a transgender person in the commission. I don't care whether it's gay or not gay. It is beyond gay, I think, someday. I don't know. But that apart, you can have a large commission which will decide, hopefully by unanimity, but always sensitive to judicial supremacy, ways can be found, but nobody shall have a veto. And that can be done, that can be attempted.
Madhvi, before you just comment, just building on this, I was just struck by the faith that both of you have in the political process to bring about the social inclusivity and diversity. And I'm not saying that the judiciary is some great example of that. But I'm saying for me, the faith on the other side also seems equally misplaced. And I think the problem of social inclusivity and diversity is more structural than one wing of the state being able to do it better than another wing of the state. Yeah.
Okay, first of all, I think the eminent persons are to be appointed by not the executive, but by a three-member committee of the Prime Minister, the Leader of the Opposition, and the Chief Justice of India. That's important. So the Chief Justice of India has a say in had a say in the appointment of the eminent persons. And if, we have Chief Election Commissioners, we have a CVC, all of these people are, perfectly independent people. So why should we be so quickly, so cynical about who we can get? As far as qualifications are concerned, I think, when we're talking about generally eminent persons from outside of the law, why should we restrict it? It may be, a great filmmaker like a Satyajit Ray, or it could be anybody. The discipline doesn't matter. I think you just want somebody who's socially sensitive and who would ensure that you get good people in. That's one. We have to trust our three top constitutional functionaries. That's one. The second thing about, so much was said about the basic structure and about primacy in the abstract. I think in this particular case, what it really boiled down to is whether what I call the right to insist by the judiciary, and I'll explain this. Because if the judges find on the commission were to find that a particular candidate was an undesirable one, then they had that so-called veto with them, and two of them could simply block that appointment, and it would never happen. Therefore, no appointment on the commission could ever happen if if 2 out of 3 judges were to say no. That's number one. The only thing is that if the judges want a particular candidate, and 2 other members, whoever they are, were to say, were to put their foot down and say no, then perhaps it would not go through, because that is a so-called veto, which would be. Now, therefore, the question is, in the light of objections by 2 other members, should the judges have the right to insist upon that appointment going through? Because presumably, if 2 other people have objections, it would be for good reasons, because these are objections against a candidate who is recommended by or approved of by 2 other judges. So therefore, what it boils down to is this right to insist, and that is not part of primacy as explained in the second judge's case, because the second judge's case says that the primacy is in appointment, not in non-appointment. So the judges can prevent a bad egg from coming in. But if somebody else were to object to their appointee, then perhaps they wouldn't be able to push him through. And as far as, again, the veto is concerned, one way of looking at it is a veto of 2, 2 out of 6. But the other way of looking at it, it's a special majority of 5:6. That's what it boils down to, because you have to have 5 saying yes for it to go through. So that is, the other way of looking at it. Yeah, thanks.
I just want to address your question about faith in the political class and the political process, which you seem to imply is something naive. No, that's the implication. You think it's a very touching faith. Now, I'll give only one reason why. When civil liberties were in danger, were taken away in our country during the emergency, it was the political class and the political process which restored those civil liberties to us, not the judiciary.
Mr. Ramchandran, is there? And this is my last question, and you can have a reply, and we can go to audience questions. But is there any point in we can stack up examples on either side, right? Where the judiciary has saved the day and where Parliament has saved the day. But I was wondering if something that Professor Bakshi wrote in the Indian Express about, there's a need to distinguish between constitutional politics in that sense, which I don't think we should have a problem with, between institutions playing out that kind of constitutional politics, as opposed to something like a party politics. There's no constitutional purpose served in that sense. So viewing this as some sort of self-serving party politics, power brokering kind of framework.
I'm glad you mentioned this, because that's where I come from. Now, it is convenient to think of this amendment as coming from this particular government, which so many of us, me included, let me reiterate my position, I am as uncomfortable as so many others are about the future of the idea of India under this government. But we have to discuss it at a constitutional plane, on a constitutional plane, in terms of constitutional theory, in terms of political theory. And that is why I take the stand that this particular judgment, the effect of this particular judgment, is completely anti-democratic.
Thank you so much. I think we have about 20 minutes for questions before we are asked to vacate the auditorium. If we can have short questions, very quick questions, we can take as many. If we have 2 questions, we can start with 2 questions here in the front.
Whereas I hold no brief for the present government or any government for it. When the judges are appointed in a high court by the collegium, there is a long assembly lineage of judges who will be chief justices, and some of them will come to the Supreme Court. So when they become chief justices, they are very good. But when they come to the gates of the Supreme Court, some of them are good, some of them are not. So the collegium will look at their face and say, you come in and you don't come in. I believe there is any danger to the independence of judiciary, it is from the judiciary itself. So how do you correct the system? Collegium or non-collegium is not the issue. Neither NJ is the issue. Now the country is looking at a system which will inspire confidence in the people that you have a judiciary which will give you fair justice. That's the issue.
It would be great if you could also just introduce yourself. That was Professor Ranbir Singh, Vice Chancellor of National University, Delhi.
Yeah, I'm Mukul Mugdal. I have a caveat to put. I was the advocate on record for the Advocates on Record Association in the second judge's case. But what I'd like to say is, what Mr. Ramchandran said about independence of judiciary, protection from executive excesses, there has to be a protection on independence of judiciary from the collegium excesses also, which is very well reflected in the judgments of Justice Joseph and Justice Chalmeshwar. We know judges who have not given a single judgment have been appointed to the Supreme Court. We have judges who are perpetually late, if not absent from their seats, who have been appointed to the Supreme Court. And as Professor Ranbir Singh said, that it is one more important thing which I'd like to point out, the independence of judiciary, particularly the high courts, is affected by this seminar culture every weekend. Most of the seminars are wholly irrelevant and do not contribute anything to the growth of law.
But Justice Mudgal, what you said is what was said in this recent case by some of the counsel led by the Attorney General. One judge says it was a vitriolic attack.
Any more questions? Yeah, there's a question there.
Sir, my name is Prashant. I am a lawyer. My question is to Dr. Bakshi. Sir, you have mentioned some names who who could be eminent persons. You have mentioned Baba Amte and Mother Teresa. Do you feel that Kailash Satyarthi or Metha Patkar or Vandana Shiva or somebody like that, will they take away the judicial independence if they were members in the appointment commission? And these judges become members of collegium only by chance, by seniority. Do you trust them more than these persons who have devoted their whole life for social justice?
Well, should we take one more question? Yeah. Yeah.
Hello everybody, my name is Navneet and I am a student of law. And my question is that in this debate of having diversity in the appointment process and in the judiciary, we are forgetting one of the instruments that is mentioned in the constitution, that is Article 124(3) of appointing law teachers as members of the judiciary. So in this debate, why haven't we been exposed to idea of law teachers being appointed as judges?
I say that beyond recall, successive presidents of India in Raisana Hills have looked through their telescope to find a jurist and have not found one. 70 years. I would expect that to happen. The only person who really wanted to be a judge of the Supreme Court was my colleague and deserved to be one, Pradyumna Kumar Tripathi. And he died a very unhappy man because he was not, by judges borrowed from him, they never acknowledged him. Many of us are interested in becoming judges.
Were you ever
That's
considered?
irrelevant.
Were you ever considered?
No. I'm not interested. I'm not made of the type which judges' cases say, that this thing and that thing and that thing to a judge. I don't have those many qualities. I don't know whether any judge has those many qualities, but I don't. So I'm happy as a law teacher, but their idea is they don't pursue it. At least do it nowhere. 70 years is good enough time to forget that idea. Constitution made a mistake. Obviously, constitution makers made a mistake. And we should accept it. And not many presidents, also chief justices, all these people. So there's now a consensus among the judicial and political class about law teachers. Forget about it. The idea might be very good, but it's irrelevant. Now, I'm not concerned with giving out names of people, but certainly technically a litigant includes a public interest petitioner. And therefore, some of the names to mention, however eminent, and I agree they should be there on the collegium, may not become, because they are already in one case or another in which I'm helping them or not helping them. But we should find people who do nothing with the courts. Or while they are in the courts, they have no case pending before any court in India. Therefore, that class is out, in my opinion. On the question of, I forgot most of the question, but on the question of what classes of people you trust, political classes or judiciary, it very much depends on the context. I would not trust the political classes of any kind since independence till now to protect my liberties and rights. I simply would trust the judges. I would trust political classes for a variety of other things. Because competition for power in India has meant very different things than competition for power means in other democracies. Competition for power resides in one fact: how to render citizens into subjects all over again, regardless of which. And when competition of power is directed to that aim, I won't trust the political class to protect my rights and freedoms. I won't occasionally trust the judiciary. But what option do I have? I have to trust some institution. So judiciary is not my institution of choice, but of necessity. It is my institution that I trust as a citizen. On all other matters, I don't care. I trust the political classes or the business classes. You can trust, it's a very wide world, you can trust anybody you like. poor me is concerned, I'm a small man, and the fact that I'm a small man is proved every day, every minute, especially now in my youth, in my second youth. So it's all right, it doesn't matter. You make your own choices, but I'm saying that you need to have as a citizen faith, ultimate faith, in the subaltern masses of India. And I'm basing your time and mine when I say this, because you people belong, like me, to upper middle class or middle classes. And you are not likely to give a second thought to really impoverish people of India. But if you have time, and if you have some developer inclination, I request to you is, this is settled option. There's no meaning whether you trust judges or you trust coalitions. And don't ever make the mistake when the chips are down. Courts are as much organs of governance as the state executive is. There is no difference when the chips are down. Even today, if you look at the so-called terror case, when the courts acquit a person after 14 years, 16 years, because the police is not willing to able to produce evidence after so many lapse of years. There are tons of cases. When the chips are down, when the security and the integrity of India is concerned, there is no difference between the police thana and the Supreme Court and the Prime Minister. When they feel, the citizens are nowhere, and their faith is irrelevant. They behave all the same way. You look at Manorama, and who's been raped by special police, Assam Force Act. You look at the act, you look at Jivan Reddy, Justice Jivan Reddy, my friend, has said why he should stay, it should be made more permanent. He went to Assam and northeastern states, and he found that the main grievance was that the ASFA was only directed to northeast. So he said, oh, that's very good, we should generalize it to communal disturbances act. So his idea is to apply to all of India, so that his people would not have any grievance that it applies to them. And that's what he did, proposed, and that became law in the earlier regime. So, my friend, if you are really concerned with people at the bottom, you will do many different things than devote your time to what judiciary or political classes do. So if you are concerned with yourselves and your likes, yeah, this is a very important debate. And I hope I have contributed some misleading and mischievous things to it.
Can we have the last set of 3 questions? If we can take the person there and the 2 people sitting at the back.
Good evening, sir. My name is Ankit Sharma. I'm an advocate at the Bombay High Court. My question is to Mr. Ramachandran. The question pertaining to the relevant social philosophy. Now we have something like a civil service neutrality for the civil servants. In the same scenario, analogous, do we have any neutrality when it comes to appointment of judges according to the Constitution? Pertaining to that also is the question, does the social philosophy of the judge sacrifice on the merits of the cases he decides? Thank you.
Thank you.
Yeah, just last.
I have a question for Ms. Divan. You rightly pointed out that the NGAC provides for social diversity, and you also said that in Australia homosocial reproduction has been studied, that judges like to see those people like to appoint those people who share their social philosophy. You gave an illustrative example that a black woman may feel that she will not get justice from an all-white bench in South Africa. But don't you think that the problem with this narrative is that it presumes that all social groups are monolithic communities, and judges from the same social groups will have the same social philosophies? For example, in United States, Anthony Kennedy and Antonin Scalia are both Catholics, but on controversial issues like marriage equality and abortion, they differ greatly from each other. So how would you respond to that?
Let's take the last question. Hi, my name is Gaurav and I'm a student of law.
My question is, do you see this NJAC verdict of the Supreme Court as a sort of as an anomaly? Because usually what happens is, if you go back to 2005 in the case of beef ban, Supreme Court very easily just gets swayed by the arguments of the state, and such flimsy arguments like only a handful of like 2% of people would be affected, so you can compromise on the fundamental rights of those people. So it's like when the so-called fundamental rights of Supreme Court are sort of compromised, then they stand against the government, but otherwise they are almost playing hand to hand with the state. Thanks.
Let me address the social philosophy question. Now first, civil service neutrality, which you talked about. My understanding of civil service neutrality is that you shouldn't be partisan to one political master, which means a civil servant should not be a BJP guy, he should not be a Congress guy. But civil service neutrality doesn't mean that you are not in tune with the ideals of the Constitution, with fundamental rights, with directive principles. The difference between a good bureaucrat and a bad bureaucrat is this: a good bureaucrat is one who doesn't bow to a political master except in the chain of command, but is in tune with the ideals of our Constitution. So equally, in the judicial sphere, neutrality must be seen in this context. When our Constitution, like all constitutions, is a social document, judges are not deciding cases as if they are deciding a civil suit, where they only have to assess the evidence and apply the law. I've often given this example of a former Chief Justice of India who retired not very long ago, who writes in a judgment on reservations that reservation itself implies mediocrity. Now, a judge who's sworn to uphold the Constitution, a Constitution which has affirmative action written in it, if he has this inborn bias against reservation, because our Constitution contemplates not just affirmative action generally, but reservation is part of our constitutional scheme. If a judge is not in tune with this scheme, he certainly needs to be interrogated on it. So the point which I am trying to make is, for a constitutional court, social philosophy and being in tune with the ideals of the Constitution is a must.
Yeah, those two questions at the back. One, on this aspect of social diversity, of course, this was not to suggest that if there is a South African bench of all white men, it doesn't necessarily mean, number one, that they will not do justice, nor does it mean that they share the same social philosophy. The idea of having diversity on the bench is to inspire public confidence that this is a bench, a court which represents society, and even though my case may land up, if I'm a black woman and my case lands up before a white judge, I feel that ultimately this court itself overall is representative of society and of not just one class of people. And the studies in Australia showed this, it's called either judicial cloning or homosocial reproduction, that and unwittingly and acting completely bona fide, if a judge were to be required to suggest names for appointment, he may be likely to look at somebody in his own his own image. He may want to perpetuate that without meaning any harm at all. So the idea is under this system it was at least to try and widen the net, so that you at least you're able to reach out to many more people, because under the collegium the grievance was that you're only looking at those, somebody mentions that so and so is a good candidate, he or she is practicing in such and such court, etc. So therefore the net is cast very not wide enough, and therefore there may be people, for example, practicing in a district judge somewhere. Now the High Court chief, suppose that someone practicing in the some far-flung area of Maharashtra, and the High Court, the Chief Justice of the Bombay High Court may not even know this person. So therefore, how are to widen the net is the whole object of this process. And the second question on the idea was, and the attempt was, to have the matter referred to a larger bench, because one, we knew that given the fact that the 9 judges, the second judge's case stood in the way of a bench of 5 judges, and secondly also because it was ultimately the judges deciding on their own powers. So to that extent there was an inevitable conflict, but the doctrine of necessity requires that it is heard by the judges. But therefore the attempt was to try and get it referred to as large a bench as possible, so that at least in the public's mind also there is that much more confidence that, and to give you one example, in Pakistan a similar thing happened, and they referred it to their full bench of I think 17 judges. So that itself was very symbolic.
If I may just quickly respond, I think that on the diversity question, the idea is not as much to represent ideas on the bench. It's not to say that a scheduled caste woman on the bench is the best representative for the ideas or benefits of scheduled caste women. I don't think that's the idea. I don't think you can ever ensure that, right? But the question is of presence, right? As Mr. Devan was saying, that it's that distinction between the politics of ideas, that why can't you obviously wouldn't make the argument that men can represent the interests of women just as well in, let's say, in parliament, right? So the question is not of how well will they further the interest of that group. I don't think it's about the presence. And as far as deference is concerned, I think it's a very problematic area for constitutional jurisprudence, that courts have never really developed any theory of deference. In which situations will they defer? In which situations will they not defer? Now, if you look at situations where there is the maximum infraction on rights, courts, like national security laws, courts seem to be extremely deferential, right? Whereas in so many other contexts, courts are so much more interventionist. And clearly that connection between degree of infraction of rights and the degree of deference has not been made, and it seems to be anyone's game in as far as that's concerned. Anybody? Any more comments? Okay. On that note, thank you very much, and thank you all of you for staying back this long. Right. Now, of course, it wouldn't be complete without me thanking the students who run the Public Law and Policy Discussion Group. They have dealt with issues ranging from the absolutely inane to the profound in getting this done, and it'd be surprising how inane the inane got. But anyway, thank you so much to all of you. A wonderful effort, and we hope we can do more of these things. And of course, these issues are evolving. These constitutional dynamics are evolving. And on that note of evolution, we have a copy of the rather controversial book, The South African Gandhi, The Stretcher Bearer of Empire, for each of you. And if I may just request Siddharth to give a copy each. Yeah. Thank you so much, everyone, and good night. Thank you.